Hello guys, welcome to our YouTube channel TechSaj where we share legal, taxation and financial matters. आज के इस वीडियो में हम डिस्कस करेंगे अबाउट डॉक्ट्रिन ऑफ प्रॉमिसरी एस्टोपेल. नाम से ही पता चल रहा है दिस डॉक्ट्रिन इज रिगार्डिंग प्रॉमिस. प्रॉमिस मतलब वो दोस्ती वाला प्रॉमिस नहीं. It's in regards to business transaction, whether contract or not. Contract में तो आप torts में legally bind हो. You have given somebody a written contract that you will pay on the delivery or something like that. वो तो आपको करना होगा. Promissory estoppel is something that protects your rights even if it is a drafted agreement or not. This promissory estoppel is binding on the individual as well as on the governments. वो भी ऐसा नहीं है कि प्रॉमिस किए और मुकर गए तो चलेगा. No, this estoppel bounds them as well. Now let's discuss about understanding the promissory estoppel. Promissory estoppel protects the right of the aggrieved party in the case of a default. I have promised to a guy that you deliver me 2 horses and I will pay you upon the delivery. उसने 2 horses मुझे पहुंचा दिए मेरे फार्म हाउस पे. मैं पैसे देने से उसे मुकर गया. No, this is a default. This is a default in the eyes of promissory estoppel. I cannot say कि भाई मैंने तुझे लिख के नहीं दिया था, कोई एग्रीमेंट नहीं है, मैं नहीं दूंगा. No. Delhi government has marked a particular piece of land as commercial land. मैंने वहाँ पे ज़मीन ली, फैक्ट्री बनाई. कल के डेट पे गवर्नमेंट का मूड चेंज हो गया, उसने उसे वापस एग्रीकल्चरल जोन घोषित कर दिया और बोलेगा कि फैक्ट्री बंद करो. नो, दिस इज़ नॉट द वे. You have promised to the citizen कि ये कमर्शियल जोन है, यहाँ कमर्शियल एक्टिविटी होगी. I have done the deeds according to the purview of the law and I am protected by promissory estoppel to not to do otherwise. This promissory estoppel protects non-performance, protects loss, protects damage or any kind of interest that I have built up based on the promise of the said party. That party can be an individual, that party can be a government, that party can be executive, no matter. But my rights are protected. ये होता है promissory estoppel. The arena of this doctrine is somewhat vague, but as per section 25 of the Indian Contracts Act, there are guidelines that is building up according to the latest amendment of 108th report. A draft is being prepared to make it clear in the ambit of law. As of now, there is no certain guarantee of the relief or damages under this doctrine, but there are judgments, there are case laws which protects the right of the aggrieved party on the base of rule of law, justice and consciousness. The doctrine of estoppel in India is a part of rule of evidence included in section 115 of the Indian Evidence Act 1872. The section says when an individual has acted or prevented from acting by omission or an act intentionally promised or accredited any other party. देखते हैं सेक्शन 115 क्या कहता है. Section 115 of the Indian Evidence Act 1872. This says the doctrine of estoppel in India is a rule of evidence included into the sections, which says when an individual has by his declaration, act or omission intentionally prompted or accredited every other individual to accept as true with this type of elements to be real, and to act upon such notion, neither that individual nor his consultant would be allowed in any shape or proceeding among himself and such individual or his representative to disclaim the reality of that issue. Promissory estoppel is related to future promises, whereas section 115 talks about representation regarding existing facts. Promissory estoppel's application can invalidate the constitutional provision provided under Article 299, which talks about immunity granted against the personal accountability of an individual making the promise. देखते हैं what are the factors to consider while applying the doctrine of estoppel. The factors to consider. The doctrine seeks to enforce a promise made under a contract, whether oral or in writing. The promise should have suffered an economic loss. The promisee or aggrieved party can recover damages from the promisor for any losses incurred as a result of the contract. A formal consideration is not required from the promisor to the promisee under the contract. The promisee should be one on which a reasonable man could have relied on. The promisee should have acted reasonably and relied on the promise. The doctrine enables the injured party or the promisee to recover on a promise. The necessary conditions for making a claim under the doctrine of promissory estoppel are there should be a promisor, a promisee, and the promisee should have suffered a loss. Courts will enforce the doctrine of promissory estoppel if the performance of the promise is the only way of granting justice to the aggrieved party or the promise. Now let's discuss about the evolution of doctrine of promissory estoppel. There are three different case laws which will enlighten on this topic. Let's discuss them. In the case of Ganges Manufacturing versus Surajmal, in 1880 the concept of promissory estoppel was originated in the Indian law system through this case, when Calcutta High Court upheld that a promise without consideration was enforceable merely on the basis of interest and reliance. In 1892, judgment of Calcutta High Court was not followed as Madras High Court dismissed the basis of interest and reliance and returned back to the traditional approach that consideration is necessary. In Union of India versus Anglo-Afghan agencies, the doctrine of promissory estoppel found its complete explanation in the case of Union of India. Earlier, promissory estoppel was never applied against the government, but with time, this case changed the position. To uplift export of woolen garments to Afghanistan, the government made a declaration about specific modification regarding the import of specific raw materials. But later, only limited modification was permitted. Not all modifications as promised were permitted. The government was held liable by the Supreme Court as they were stopped by its promise. So the promissory estoppel was applied against the government by the courts. The doctrine of promissory estoppel was fully accepted in India, devoid of notion of consideration, and made it familiar as a reason of action to the parties to whom the promise was made. Now let's discuss what are the fundamental components of promissory estoppel. Number one, lawful relationship. There must be an existence of lawful relationship between both the parties, the aggrieved and the default, to establish this doctrine. Second point, assurance. It must be clearly displayed that the promise was made and the other party has acted upon or had prevented from acting upon due to that certain promise. Such a promise must be reasonable. Third point, reliance. Aggrieved party's reliance on the promise made must be vividly displayed, because of which the aggrieved party took some decision. Fourth point is damage. It must be known that the party has suffered some loss due to the action for which he must be compensated. Unaccountability. It must be clearly displayed that it was unjust and unrightful to break the promise for which the aggrieved party has got some loss. If all these 5 points are present in a contract or promise, it must be within the ambit of doctrine of promissory estoppel. Now let's discuss about promissory estoppel in India. Right before this doctrine was established, there was a case in Calcutta High Court that saw that this doctrine was not kept in separation of the evidence law. An individual can be stopped from doing an act or act distinctively depending upon special reasons. In a later case, Bombay High Court saw this firm decision.
In the case of Bombay High Court, in a later case, the Bombay High Court empowered the municipality to oppose the case of the Secretary of State to be launched. Starting from the earlier stage, the municipality had leveled and raised versatile claims in the conviction that they had a flat out right which should not be turned out except if other reasonable ground was outfitted. A conviction which was preferable to a desire made by the administrative authority which the legislature realized that the municipality would act upon.
In a much later case, Supreme Court established the relation in this.
In this case in Supreme Court, much later, the Supreme Court connected the standards with one judge really utilizing the term promissory estoppel to block the administration from evaluating land income in connection to a market site, when it had prior settled not to charge any lease on business sectors for business sectors would resemble other open buildings.
In a distinct case between Ulhasnagar Spinning and the municipality, we can see.
In this case of Century Spinning and Manufacturing Company Limited versus Ulhasnagar Municipality, in this case the doctrine was connected to implement a guarantee of exception from the installment of octroi obligation given by a metropolitan organization. The court drew the refinement between the portrayal of the current actuality and description that something would be done in future was spelt out, and it was thus carefully observed. At last, in the Supreme Court managed the doctrine of promissory estoppel at the incredible length and held that it afforded a reason for the activity.
And the iconic case law of Motilal Padmavat sugar mill case versus the state of UP, where he set up a factory due to the guidelines of the government and then government stepped back.
In Motilal Padmavat sugar mills versus state of UP, for this situation in this case wherein the government of Uttar Pradesh proclaimed a plan exempting all new modern units from deals charges for a long time in the paper, the appealing party sugar organization got the portrayal found from the Secretary Industries Department, the Director of Industries and the Chief Secretary expressing that in perspective on the business charge exception declared by the administration is expected to set up a hydro generation plant for Vanaspati.
There should be no estoppel against minors. Various Chief Justice have said their decision again and again that whether a guy has depicted his age wrong and tried to act as a major and establish in a contract, जो भी सिनेरियो रहा हो, लेकिन एक माइनर को कभी हम प्रॉमिसरी एस्टोपेल के डॉक्ट्राइन के एम्बिट में नहीं ला सकते हैं. अब ट्रिपल सिनेरियो देखते हैं बहुत सारे केस लॉज का, जहाँ पे इशू जो था किस फैक्ट के बेस पे था और कोर्ट ने इसे क्या हेल्ड किया. तीनों चीज़ हम देखते हैं.
In the case of Motilal Padampat Sugar Mills versus State of Uttar Pradesh and others, in this 1979 case, these are the facts. There was an announcement made by the Uttar Pradesh government that all new industrial units of the state will be relieved from the sales tax for the upcoming 3 years. After this announcement, the plaintiff went for confirmation to the Director of Industries, who restated the announcement made by the government earlier. Chief Secretary of Government on behalf of the Uttar Pradesh government gave clear assurance to the plaintiff about the same. After getting definite assurance, the plaintiff thought of setting up a new plant in Uttar Pradesh, and for this he took a large amount of money on credit from monetary organization. Afterwards, the government made some changes in the announcement and assured to offer limited concession. Plaintiff agreed to the assurance and started his work. However, the state government after some time denied to grant any kind of concession. This left the plaintiff with no other option than to sue the government on account of a promissory estoppel. The issues that were faced in this case was, by giving the consent to limited concession, did the plaintiff surrender his right to have a cause of action? On grounds of promissory estoppel, can the plaintiff have a cause of action? Whether any action taken against the government while acting in administrative capacity can lie, can a plaintiff's action be destined to succeed in this case? It was held that the writ was dismissed by the High Court of Uttar Pradesh and also rejected the plea against the government of Uttar Pradesh of Promissory Estoppel. The Supreme Court heard the plea and held that appellant on the assurance made by the government took a loan. The government, by his words, made a clear promise which created a lawful relationship between both the parties, and the appellant relied on the assurance and acted upon it. Therefore, the promise would be obligatory on the part who made it and cannot back up from his words. The appellant suffered a detriment because of the assurance given by the government. It would be unfair to allow the government to back up from his words, as the appellant acted upon the promise that resulted in changing the position which cannot be reinstated. Appellant not only took loan but also purchased machinery and established the hydro generation plant, so promissory estoppel can be invoked.
So let's conclude this. Government of India is also under the ambit of promissory estoppel. वो भी इससे बच नहीं सकते हैं, भले ही एक क्लियर लॉ ना हो इंडिया में, बट स्टिल हमारा जो जुडिशियल रिव्यू है, जो हमारी पॉलिसी है विच इज़ बेस्ड ऑन प्रिंसिपल ऑफ नेचुरल जस्टिस, उसके तहत डॉक्ट्राइन ऑफ प्रॉमिसरी एस्टोपेल आता है और ये इसी के अंदर परव्यू किया जाता है. तो ये रहा हमारा आज का टॉपिक. दिस वे आई एंड द वीडियो. इफ़ यू हैव एनीथिंग एल्स टू आस्क, यू डू राइट इन द कमेंट सेक्शन. वी विल ट्राई टू आंसर दैट ASAP. और ये पूरी प्लेलिस्ट हमारी प्रिंसिपल ऑफ नेचुरल जस्टिस के ऊपर है. इसकी एक वीडियो और आनी है, दैट इज़ डॉक्ट्राइन ऑफ प्रोपोर्शनैलिटी. थैंक यू गाइस. अगर आपने अभी तक चैनल को सब्सक्राइब नहीं किया तो डू सब्सक्राइब और बेल आइकन को ज़रूर दबा दें ताकि आपके पास नोटिफिकेशन पहले पहुंचे. थैंक यू.